three-judge panel established by the Tennessee General Assembly and selected by the Tennessee Supreme Court for this particular case will now transact the business for which it was created. All persons having business before the court, draw near, give attention, and you shall be heard. God save the United States, the great state of Tennessee, and this honorable court. The Honorable Ann C. Martin, A. Blake Neill, and Pamela A. Fleenor presiding.
Good afternoon. I'm Chancellor Ann Martin with the 20th Judicial District. I'm the presiding judge in this case. I'm going to start by introducing the other two judges on the panel with us. We have Chancellor Pamela Fleenor from the 11th Judicial District in East Tennessee, and Judge Blake Neill from the 25th Judicial District in West Tennessee. And we are pleased to hear this matter today. We'd like to, for the record, have the lawyers introduce themselves, first representing the plaintiffs.
Good afternoon, Your Honor. I'm Rick Colbert from Nashville. I represent all of the plaintiffs. My co-counsel, Steve McLeod, Alice O'Brien, and Jennifer Hunter are observed. They're in the room and they're observing as well.
Thank you so much, Mr. Colbert. And on behalf of Governor Lee and the Commissioner of Education.
Yes, Your Honor, I'm Miranda Jones on behalf of Governor Lee, and tactful of you to say Commissioner of Education since it was Piercy, but it is currently Lizette Gonzalez Reynolds now that her official swearing in has occurred. On the call with me are Kevin Kreutz and Reed Smith. Reed Smith is co-counsel in the case, and Kevin is another attorney in our office.
Yes, thank you so much. I did note that that change had occurred in the time that this case had pended. All right, we are here today on the plaintiff's motion for a temporary injunction. The panel had entered a temporary restraining order on June 29th of 2023, and the motion essentially seeks to convert that to a temporary injunction. I do understand that we have a court reporter on who's recording the proceedings. Also, because it is Zoom, for purposes to assist us with having the best audio possible, everyone please mute your microphones unless you, of course, are speaking or asking a question. And with those preliminaries, is there anything that the plaintiff has before we start the argument?
I have no preliminary matters, Your Honor.
Ms. Jones, anything on behalf of the state?
No, Your Honor.
All right. So, Mr. Colbert, we are ready to hear you when you're ready to proceed.
Thank you, Your Honor. With Mr. McLeod, Ms. O'Brien, Ms. Hunter, and Mr. Hostek, who could not be at this Zoom meeting, we represent the Tennessee Education Association, 3 local affiliates of the Tennessee Education Association, one from Metro Nashville, one from Knoxville, and one from Lawrence County, and 2 individual members. We're here today on our application to enjoin the implementation and enforcement of Section 2 of Chapter 437 of the Public Acts of 2023. Consistent with Tennessee Code Annotated Section 1-3-110, we only seek an injunction as to Section 2, since Section 1 of the Act, standing alone, would pass constitutional muster. This Act began as a caption bill, or what Tom Humphrey, a longtime political beat writer for the Knoxville News Sentinel, calls institutional sneakiness. It was an administration bill whose initial sponsors, as administration bills are, were Senator Johnson and the majority leader in the Senate, and Representative Lambert, the majority leader in the House. The caption of the bill said, "An act to amend Tennessee Code Annotated, Title 49, Chapter 2, Part 1, and Title 49, Chapter 3, Part 3, relative to wages." The initial content of the bill was simply a requirement that the commissioner publish the annual state salary schedule for teachers on the department's website. But as amended and as as it was passed and became law, the bill had two primary sections. Section 1 was an increase in the base salary for teachers on the state minimum salary schedule that would get that base salary up to $50,000 over a 4-year period. And Section 2, the part of the act that we're here about today, was a ban on payroll deduction of association dues. The Section 2 ban on payroll deduction of association dues applies whether that payroll deduction is done through a memorandum of understanding or MOU under the Professional Educators Collaborative Conferencing Act, which I'll refer to from now on as PECA, or local board policy. Either way, payroll deduction of dues is banned by Section 2 of the Act. We ask this court to issue a preliminary injunction during the pendency of this case enjoining the Section 2 ban because it is unconstitutional in 4 ways. It violates Article 2, Section 17 of the Tennessee Constitution in 3 different respects, which we'll get into. And it also is contrary to the contract clauses of the state and federal constitutions. Before I get too deep into our legal arguments, I would like to give the court just a little bit of background. I know we've briefed this case pretty extensively, but I want to touch on some important points of background interest. The Tennessee Education Association and the local association plaintiffs here are voluntary associations. They work and advocate for public school teachers and for public education generally throughout Tennessee. The members of these associations choose to join, and the members control every aspect of how the associations work, from structure to mission to governance, even to establishing what the dues will be. There's a consolidated membership structure for the national association, the state association, and the local affiliates, all of which are affiliated with each other. And that consolidated structure occurs because benefits of membership are provided at various levels between the different organizations. So when a teacher joins one, they join all 3, the national, state, and local affiliates. The benefits of membership include eligibility for legal services, insurance coverage, professional development opportunities, and perhaps most importantly, the opportunity to be part of a collective voice on matters related to public education and public school teachers. Membership is completely voluntary. There is no teacher in Tennessee who is required to join the association. That's established as a matter of fact in the verified complaint and in the declarations that we filed with the complaint. And it is established in Tennessee law. Tennessee has had on its books since 1947 a right to work statute in Tennessee Code Annotated Section 50-1-201. PECA, which I referred to earlier, also has its own right to work provision in Tennessee Code Annotated Section 49-5-603, which clearly declares that teachers have a right not to join an association. And last year, Tennessee enshrined the same right to work protection that it's had by statute for over 75 years into what is now Article 11, Section 19 of the Tennessee Constitution. In addition to membership being voluntary, the payment of dues by payroll deduction, where available, also is voluntary. A teacher who joins the association has the option to pay their dues by multiple different means. They can pay them by check, they can pay them in cash, they can pay them by credit card, electronic funds transfer, or if offered by the local school district, they can pay them by payroll deduction. Payroll deduction in and of itself is voluntary on the part of the school districts as well, either through an MOU that a school district has voluntarily agreed to under PECA, or through a board policy that the board has voluntarily adopted. No board is required to agree to payroll deduction in an MOU or to permit it as a matter of local policy, but they do because they know it's a convenience for employees and it costs the board little or nothing. In Section 2 of this act, the legislature has attempted to take this voluntary choice away from teachers and local education agencies. The governor dubbed this new law the Teacher Paycheck Protection Act. After he signed the act into law on May 15, he declared that in addition to increasing the starting salaries for teachers, Section 2 of this act, quote, ensures union dues are no longer collected by school districts, giving teachers control of their own hard-earned paycheck. Senator Johnson, the Senate Republican leader, declared on the Senate floor that, quote, this is a matter of whether or not the state should force our local education agencies to collect and remit payment of dues to a union. And Representative Deborah Moody, who introduced the amended version of the bill in the House, was quoted in the state's May 18 press release after the governor signed the bill as saying that the act, quote, protects tax dollars from being used to benefit organizations like labor unions. These explanations, anecdotal as they are, about Section 2 of the act are divorced from reality. No local education agency has ever been forced by the state to offer payroll deduction of dues to teachers. Teachers already have control of their paychecks. Teacher membership and payment of dues by any means is completely voluntary. And payroll deduction does not deprive teachers of control of their paychecks. It offers them a convenience, not a burden. It's a reliable, convenient, and secure way for teachers to ensure uninterrupted membership in their association. Employees everywhere in all walks of life understand the benefits of payroll deduction. We pay insurance premiums, health savings account contributions, FSA contributions, cafeteria plan payments, 401k contributions, all are paid by payroll deduction. It is also not a burden for sophisticated employers like school districts. They have sophisticated payroll practices. They already have multiple payroll deductions in place for employees, and adding one more is just a simple keystroke on a computer for a data entry person. And that's why the fiscal notes prepared by the Fiscal Review Committee of the legislature, multiple fiscal notes for this bill, show no decrease in local education agency expenditures as a result of this ban on payroll deductions. The court is very familiar with the 4 factors for granting or denying an injunction. There's the threat of irreparable harm to the plaintiffs, the balance between that and any harm to the defendants, public interest, and the likelihood of success on the merits, which in a constitutional case like this one is the most critical factor. Irreparable harm is presumed when constitutional rights are threatened, and the sworn complaint in this case establishes irreparable harm in the form of unrecoverable financial losses by the association. There will be no harm to the defendants if Section 2 of this act is enjoined. Public interest is served by an injunction. Tens of thousands of teachers will be affected by this injunction, plus the public interest generally favors enjoining an unconstitutional law. And that brings us to the likelihood of success, the key factor here. Here we need only establish a likelihood of success on any one of our 4 constitutional claims. we believe we're likely to succeed on all four, justifying an injunction. Section 2 of this act is unconstitutional under Article 2, Section 17 of our Tennessee Constitution. That article regulates how the legislature does its business, and it declares, no bill shall become a law which embraces more than one subject, that subject to be expressed in the title. All acts which repeal, revive, or amend former laws shall recite in their caption or otherwise the title or substance of the law repealed, revived, or amended. The Tennessee Supreme Court has called these plain, absolute, and unconditional limits on legislative power. That dates all the way back to Cannon versus Mathis at 55 Tennessee 504, page 517. These limitations are mandatory, not merely directory, according to the Tennessee Supreme Court. And this act in Section 2 violates these plain, absolute, unconditional, mandatory limits in three ways. First, the act embraces multiple subjects, starting salaries and payroll dues deduction. And in connection with dues deduction, it also embraces collaborative conferencing because it amends PECA by restricting the scope of collaborative conferencing. Senator Hensley, a Republican, in the Senate Education Committee on March 8, commented, it seems like we're up in Washington, D.C. with bills that cover multiple things. And he asked the governor's representative there, Brent Easley, to explain why this bill covered multiple subjects. Mr. Easley's only response was the governor thought both subjects were good public policy. The previous day in the House K-12 Education Subcommittee, Mr. Easley testified and was asked 3 times why these two matters were joined in one bill. And he gave the same non-answer 3 times, that the governor thought both were good public policy. The governor's representative had no answer because there is no answer. The state now says that both sections of the act deal with wages, but they don't. Wages are what is paid to an employee. Payroll deduction is a tool for an employee to pay something to a third party. What if an employee used a different tool to pay association dues? Cash, check, electronic funds transfer, credit card. Surely the state would not suggest that those tools are wages. And the legislature knows the difference between wages and payroll deductions because it has enshrined that difference in PECA. At 495608A, the legislature has identified 7 subjects of collaborative conferencing. The first of those subjects in subpart 1 is salaries or wages. The 7th or last of those 7 subjects in subpart 7 is payroll deductions. This act is unconstitutional because it lumps those distinct topics together, contrary to the single topic requirement in Article 2, Section 17 of the Constitution. Second.
Mr. Colbert.
Yes.
Judge Neill here before you move on. Is it your argument that these 2 sections could have never been joined together in a single bill?
Well, under the single topic requirement, I'm not sure how they would be joined together in a single bill unless there was a bill introduced. I can envision hypothetically a bill being introduced to amend PECA, which would cover the different subjects that are subjects for collaborative conferencing, and maybe the amendment of PECA, if the caption was that broad, would somehow bear upon both of them. But the way this bill was written, I don't think they can be joined together.
But Section 1 wouldn't have anything to do with PECA, right?
Section 1 doesn't have anything to do with PECA in this bill.
Okay. All right.
Section 2 most definitely does, though, have something to do with PECA. And that sort of gets into our second and third reasons why we believe this bill is unconstitutional under Article 2, Section 17. The second topic of the bill in Section 2, payroll deductions, is not expressed in the title of the act. The title, when the Constitution refers to the title of the act, it's referring to its caption. There's an old decision, Ransom, RANSOME versus the state, where the Tennessee Supreme Court explained that the title is the caption of the bill. This caption refers to Title 49, Chapter 2, Part 1, and Title 49, Chapter 3, Part 3, relative to wages. Nothing in the caption suggests that it encompasses voluntary payroll deduction of association dues. Nothing in the caption suggests that it affects teachers' rights under PECA, which is Title 49, Chapter 5, Part 6 of the code, not mentioned in the caption. Nothing in the caption suggests that this bill would impose a new restriction on the subjects of collaborative conferencing under PECA. The phrase relative to wages in the bill limits or narrows the scope of the act, and Section 2 of the act, which deals with payroll deductions and affects PECA, is beyond that narrow scope of the act. Third, and relatedly, Section 2 amends a part of the code that's not mentioned in its caption. Again, Section 2 amends, we say it repeals, but whether it amends or repeals is of no consequence. If it simply amends 495608A7 by removing payroll deduction from among the subjects of collaborative conferencing, it's an amendment of PECA. In this respect, this case is much like State versus Chastain, which we cite in our brief. It's at 871 Southwest 2nd, 661. It's a 1994 Tennessee Supreme Court decision. There, the Tennessee Supreme Court invalidated a law that allowed someone charged with DUI to challenge the constitutional validity of any prior guilty plea for DUI. The caption didn't mention anywhere that the new law effectively amended the statute of limitations and jurisdictional provisions in the Post-Conviction Procedure Act. And so the Attorney General challenged the new law's constitutionality under Article 2, Section 17. The Tennessee Supreme Court sustained that challenge because the caption did not mention that the new law effectively amended those provisions of the Post-Conviction Procedures Act. Where an act amends a statute, the statute to be amended must be identified in the caption, not merely the body of the act. That's what the Supreme Court held in the Thompson case, Tennessee Municipal League versus Thompson at 958 Southwest 2nd, 333. And it's what it held many years earlier in Hayes versus Federal Chemical at 151 Tennessee 169. It's a 1925 decision. Or, as the Attorney General has said, if the subject of an act recited in the title is the amendment of a certain statute or statutory scheme, then the body of the act may not amend a different statute or statutory scheme. That's in Tennessee Attorney General Opinion 10-122, dated December 30, 2010. This act fails that standard because the caption does not mention that it effectively amends Tennessee Code Annotated 495608A by removing payroll dues deduction from the scope of collaborative conferencing under PECA. In summary, the Act violates Article 2, Section 17 of the Tennessee Constitution in three ways. It embraces more than one subject. The subject of payroll dues deduction is not expressed in the caption, and the Act amends or repeals a portion of PECA without mention of it in the caption. Article 2, Section 17, again, is a mandatory limitation on legislative authority, and it cannot be circumvented irrespective of whatever the legislative purpose of this act may have been.
All right, Mr. Culver, Judge Neill again.
Yes.
Before you get to the contracts clause, I've got a question about 495608A7. The statute just says payroll deductions. So does it include any other conferencing? I mean, you mentioned earlier a litany of payroll deductions that exist for 401k, health savings account, flex spending accounts. So does A7 not encompass all of those types of payroll deductions?
Your Honor, in practice, I would say it doesn't. I mean, if you look at the plain words of the statute, you might suspect that it does. In practice, it doesn't. In practice, payroll deductions in school districts of health insurance, TCRS contributions, those things are handled by payroll deduction without being negotiated in an MOU. So I would tell the court that in practice, that provision deals with payroll deduction of professional association dues. But even if you took it literally and treated it as applying to all payroll deductions, this is still a partial amendment of that statute because it now limits the payroll deductions that can be conferenced and excludes professional association dues from the scope of the payroll deductions that the parties can conference about.
Okay. Thank you.
Yes, sir. Section 2 also is an unconstitutional impairment of contracts in violation of the contract clauses of the state constitution. That's Article 1, Section 20, and the federal constitution in Article 1, Section 10. It violates these provisions because it negates existing payroll dues deduction provisions in MOUs negotiated and agreed to under PECA. The state has the burden to justify that impairment by demonstrating a significant and legitimate public purpose for the ban on deductions, and B, that the impairment of contracts is a reasonable and necessary measure to further that significant and legitimate purpose. This is not the same, we submit, as a rational basis test. There needs to be some evidence of a real purpose, not an imaginary one. And before we get into what the supposed purposes are, according to the state and its briefing in this court, I would like to dispatch a couple of irrelevant matters that the state has hung its hat on in its briefing. First is the enshrinement of right to work in the state constitution last year. That enshrinement in the state constitution is a verbatim repeat of the law that's been on the books in Tennessee since 1947 at Tennessee Code Annotated 50-1-201. So as a practical matter, that addition to the Constitution changed nothing that we're here about today. Second, the state has pointed to the Supreme Court's decision in the Janus case from 2018. Janus is not relevant to the case we're here about today. Janus dealt with the First Amendment rights of non-members to not have to pay agency fees because the court deemed those agency fees to be compelled speech under the First Amendment. But in making that ruling, the court said this, and this is in footnote 27 of the Janus decision. States can keep their labor relations systems exactly as they are, only they cannot force non-members to subsidize public sector unions. In this way, these states can follow the model of the federal government and 28 other states. Tennessee is one of those 28 other states that the Supreme Court was talking about in that footnote. Those are states with right-to-work laws. And in states with right-to-work laws, public sector unions cannot charge agency fees to non-members. Non-members in Tennessee pay nothing to public sector unions. Janus changed nothing in Tennessee. Setting aside these red herrings, there are three justifications offered by the state for this payroll deduction ban and its impairment of these MOUs that allow for payroll deduction of association dues. Protecting the public fisc, ensuring educators are able to exercise informed consent to join, and preventing employees from feeling coercive pressure to join by the mere fact that payroll deduction is offered. These are imagined excuses, not significant and legitimate public purposes. Protecting the public fisc. There's no evidence that payroll deduction of dues comes at any cost to local school districts. Local school districts have sophisticated payroll practices. They engage in numerous other deductions for their employees. Adding one more deduction for an employee for association dues is a simple keystroke on a computer. The Fiscal Review Committee of the legislature found no cost savings to local education agencies from the elimination of dues deduction. Informed consent. Teachers are college-educated individuals. They're not uninformed. They're not stupid. There's no evidence that they don't understand voluntary choice, the voluntary choice to join, and the voluntary choice to have their dues paid by payroll deduction. The membership form that they sign when they join tells them it's voluntary and not a condition of employment. You can see the current membership form as Exhibit A to the declaration of Tanya Coates, the TEA president. Even if this excuse was remotely legitimate, the elimination of dues deduction would not be a reasonable and necessary endeavor to further the purported concern. The elimination of dues deduction doesn't do anything to address this concern about informed consent for those who pay their dues by cash, check, credit card, EFT, or any other means. It won't do anything to address the issue of informed consent for any member once payroll deduction is eliminated, because they'll all be paying by one of these other means. Third, coercive pressure. Again, the membership form gives teachers a choice of the method of payment. There is no evidence that the mere existence of payroll deduction in some school districts as one choice for payment operates to create some sort of coercive pressure on teachers. This excuse actually, as it's explained by the state, sounds more akin to a rational basis defense. The state says on page 30 of its brief that the General Assembly may reasonably have concluded that by participating in payroll deduction for membership dues, the state was applying coercive pressure to its employees to join Professional Employees Association, or PEAs. That speculation is supported by one anecdotal comment by one senator, a comment that cannot be reliably attributed to all members of the General Assembly, according to the Court of Appeals in DirecTV versus Roberts. That's at 477 Southwest 3rd, 293, and in particular, page 304. The reality is that this ban on payroll deduction in Section 2 of this Act is a partisan political effort to silence the collective voice of Tennessee's teachers. Consider the comments of Senator Bill Powers, a prime co-sponsor who carried this bill in the Senate. On March 8, 2023, in the Senate Education Committee, Senator Powers commented derisively about the extent of TEA's assets and how much TEA donated to political candidates. And on the Senate floor, Senator Powers commented negatively on political positions taken by the NEA and said, and I quote, "National union leaders fund left-leaning super PACs and progressive causes that just don't sync with Tennessee values." In an era when our governor and our legislature are strongly supportive of choice measures such as the ESA Act, expanded school charter schools, measures that divert funds away from public schools, TEA has been the main counter, urging greater support for our public schools across the state. Senator Yarborough said it best in the March 21 Senate Finance Ways and Means Committee meeting where this act was considered. While Section 1 of this, according to Senator Yarborough, while Section 1 of this act was an effort to catch up on teacher pay in a way that should have been done years ago, Section 2 was designed to punish those who have been urging the legislature to do so. This same reality was observed by the Sixth Circuit in the, we believe, dispositive case, Toledo Area AFL-CIO Council versus PISA. That's at 154 F. 3rd 307. And on page 325, the Sixth Circuit said, and I quote, "Even if all of these alternative motivations are imputed to the state, we cannot defer to the state's judgment that to effectuate these goals, the substantial impairment of existing contracts was necessary and reasonable. This is because the state has an obvious self-interest in muting public employee unions. The unions seek to compel public employers to give union members the greatest remuneration and benefits available in exchange for the workers' labor. As an employer, the state has an interest in diminishing the ability of public employees to gain the support of politicians and citizens in their efforts to maximize their remuneration." In PISA, the Sixth Circuit struck down an Ohio statute banning public employers from administering payroll deduction of union dues because of the federal contracts clause. Michigan State AFL-CIO versus Shewitt is another Sixth Circuit case that followed PISA. It's at 847 F. 3rd 800. It's a 2017 decision. There, the Sixth Circuit upheld a preliminary injunction issued by the district court on a payroll deduction ban. And in doing so, it only considered the last factor for an injunction, the likelihood of success on the merits. It looked to PISA and it said the debate is a legal one and the unions are on the right side of it. That's at page 805 of Shewitt, a decision written by Judge Sutton, who's now the chief judge, I think, of the Sixth Circuit. The analysis in PISA and Shewitt applies with equal force here. It makes no difference, as the state has suggested, that these decisions were decided before Janus, because as I mentioned earlier, Janus was a First Amendment case. It dealt with a completely different constitutional issue. In conclusion, Section 2 of this act is contrary to Article 2, Section 17 of the Constitution in 3 ways, and it's contrary to the Contracts Clause provisions in Article 1, Section 20 of the Tennessee Constitution and Article 1, Section 10 of the United States Constitution. The plaintiffs are substantially likely to succeed on these constitutional claims, and they will suffer irreparable harm if an injunction is not issued. The state
Mr. Colbert, can you go back to the irreparable injury factor and address the state's argument that easy pay and other mechanisms, some of which you've referred to, are available for members to pay dues, and that the lack of availability for this mechanism is not great irreparable injury?
Well, yes, Your Honor, it does create irreparable injury because easy pay and whether easy pay is accomplished via credit card or check or however it's done, those alternative methods have some costs associated with them. And I think we laid this out in the verified complaint and in the declarations in support of the complaint. There are costs associated with those measures that don't exist with payroll deduction of dues. And those are costs that the association incurs that it cannot recover. If this, again, we're here on an application for a preliminary injunction. We've sued the state effectively. The state enjoys sovereign immunity from any sort of damages claim. So we cannot recover those costs. If we have to incur all those added costs to keep our members that we don't have if they pay their dues by payroll deduction, those are costs that cannot be recovered.
Thank you for addressing that.
Yes. And finally, the state will suffer no harm if an injunction is issued, and the public interest always supports the issuance of an injunction where constitutional limitations are at issue. Consistent with Tennessee Code Annotated Section 1-3-110, we ask that this court sever the offending section of this act, Section 2, from the rest of it and issue a preliminary injunction enjoining the effectiveness of Section 2 pending a final decision on the merits of this case.
Thank you so much, Mr. Colbert. At this time, then, we will ask Ms. Jones on behalf of the state to respond.
Thank you, Your Honor. I am Miranda Jones. I'm representing the state defendants, as I mentioned earlier. And there are quite a few arguments, tests, parts, and subparts in front of the court today. So I'm going to do my best to prioritize and organize them so we can all stay on the same page here. Obviously, the first test is the temporary injunction test, which has the 4 parts, the first being likelihood of success on the merits. And plaintiffs have a high burden of persuasion as the moving party seeking extraordinary interlocutory relief. Here, plaintiffs have not shown a likelihood of success on the merits. The next part is irreparable injury, and I will address how plaintiffs have not shown an irreparable injury. And the final 2 factors, parties both agree, merge when government officials are being sued in their official capacity. Those are balance of harm and public interest. Again, both of those factors weigh in favor of the defendants. So at the conclusion of my analysis, I'll ask the court to deny plaintiff's motion for temporary injunction because they have not shown on any factor that extraordinary relief is appropriate. Turning first to the likelihood of success factor, plaintiffs have raised what boils down to 2 different claims. The first is a facial challenge under the caption clause of the Tennessee Constitution that has 3 parts. And the second is an as-applied contracts clause challenge that has 2 subparts where they claim that both certain types of memorandums of understanding and certain memberships agreements have been impaired and therefore the contracts clause is violated. I'll start with that caption clause argument. Before I get into that, I'd like to highlight for the court the purpose of the caption clause. The Tennessee Constitution gives 2 primary reasons for the caption clause. The first is to prevent legislation on incongruous and completely independent subjects. And the second is to protect legislatures and the public from surprise by hidden clauses smuggled into statutes such as omnibus statutes. There's a case that plaintiffs cite in their own reply, Illinois versus Kreider, which is a Tennessee Supreme Court case from 1892. And in it, it says the well-settled rule is that this caption clause provision should be construed liberally. Otherwise, it would operate to embarrass legislation without advancing the beneficial purpose intended. So from the get-go, this caption clause is to be construed liberally. Turning to plaintiffs' 3 challenges under the caption clause, they argue that the act violates the single subject requirement of the caption clause because it contains incongruous subjects. If y'all will bear with me, I'm going to read the caption of the act more than once in this part of my analysis. This is an act to amend Tennessee Code Annotated Title 49, Chapter 2, Part 1, and Title 49, Chapter 3, Part 3, relative to wages. That is the caption of the act we're talking about. That has been the caption of the act from day one. It hasn't changed. and it's the caption of an act that contains two parts. Section 1, which increases the minimum wages for teachers, and Section 2, which affects how schools can process automatic deductions from those wages for teachers. Now, again, to return to the case law, the Tennessee Supreme Court in Cannon, a case plaintiffs cite in their reply, says that it is up to the legislature to decide how broad and comprehensive an act should be and how much particularity should be employed in the title defining the act. So it's in the legislature's hand to decide how broad or how narrow a title should be. Here, the legislature decided on a relatively broad title, which is relative to wages. Now, we agree that the term relative to has a constraining effect on the act in a small way, in the sense that everything in the act must be relative to that term. Wages must relate to wages, must be germane to wages. Plaintiffs would place extra emphasis on the significance of the term relative to and almost suggest that there should be no deference given to the legislature if the caption uses the word relative to, because relative is such a narrowing scope of the caption. But relative to being used in a caption of an act does not affect deference. In Tipton versus Knoxville, which is a Tennessee Court of Appeals case from 2006, the caption was relative to growth. That was the caption the court was examining. And in that case, the court still stated that courts will presume that the caption adequately expresses the subject of the body of an act and avoid a technical or narrow construction of the caption. Here, as I briefly touched on earlier, both parts of the act are relative to wages. Section 1 increases the minimum wages and is therefore germane to wages. And Section 2 changes how wages are paid in a sense that schools can automatically pay wages, but they cannot automatically deduct membership dues from the employee's wages. Now, plaintiffs attempt to paint Section 2 in a different way as some sort of restriction on how employees spend their money. The Act contains no restriction on how employees can spend their money. They can spend it however they like. Instead, when schools pay money to employees, which is plaintiff's definition of wages, schools pay money to employees for work, there's a restriction on when schools may, as part of paying that money, withhold funds from those payments and send them to unions. Because this restriction deals directly with processing of wages, it is relative to wages and complies with the single subject caption clause. Now, plaintiffs also briefly argue, and I'll touch on this, that the statutory sections must be incongruous because some legislators in the legislative history didn't want to vote for both parts of the bill. That a legislator has to weigh the pros and cons of voting on an act due to a section they liked or voting against the act to a section they don't like is true of countless other pieces of legislation. That doesn't automatically make the act unconstitutional. It doesn't automatically mean that it encompasses two incongruous subjects. It is relevant to the analysis, but it is certainly not determinative. An act can serve multiple purposes that relate to the same subject. And in fact, here on March 21st, the General Assembly specifically consulted with the Office of Legal Services to confirm that the act's caption was broad enough that relative to wages could properly encompass both parts 1 and 2 of the act. I'm going to now briefly turn to the concealed contents.
Before you go on, Ms. Jones, can you address Mr. Colbert's argument that under 608A, because salaries or wages are categorized separately from payroll deductions under PECA, that is an indicator that those terms are that's not the same thing, or that they're separate subjects?
Certainly, Your Honor. The use of salary in PECA and wages or payroll in PECA as one thing different from another may have been significant in PECA, but that reading of a completely different statutory section doesn't necessarily change the meaning of the terms wages, payroll, or salary in this law. It may have significance, and I would have to read through PECA to see how that affects the act, but it doesn't necessarily mean that the word wage has to mean something different. So that's response number one. Response number two is relative to wages remains a very broad term and would encompass anything related to salary or payroll, because relative to wages would touch on payments to employees, how those payments are processed, and therefore would be broad enough to cover both points.
Thank you so much. Please continue.
Certainly. The next argument plaintiffs raise is that that Section 2 of the Act, or that the caption clause concealed Section 2 somehow. This can be just as easily disposed of as the argument about single subject. There was absolutely nothing hidden or secretive about this act, and I can address that for 4 reasons. First, as I mentioned earlier, from the start, the caption bill notified everyone that this was an act to amend 2 parts of Title 49. Chapter 3, Part 3, which is amended in Section 1 of the Act, and Chapter 2, Part 1, which is amended in Section 2 of the Act. The Act identified the exact chapter and part of Section 2 that it was going to amend, and it said it was going to amend it relative to wages. Second, this was not an omnibus bill. The Tennessee Supreme Court in Durham refers to the caption clause as maybe not requiring that a bill be omnibus, but certainly indicating that an omnibus bill or the length of a bill is relevant to determining if sections of a statute were somehow hidden. And here we have a 2-page document, 1 page of substance. This is a 1-page bill that is quite transparent in what it is trying to accomplish. There's nothing secretive in it. My third argument is that Sections 1 and 2 made up the First Amendment to the bill. At some point in their briefing, plaintiffs have claimed that Section 2 was engrafted on to this amendment. That is inaccurate. There was an original short caption bill, then the amendment made the bill, and the initial amendment that made the bill contained both Section 1 and Section 2. Finally, there is extensive legislative discussion of Section 2 in the Act, meaning nothing was hidden from the public or the legislatures. Everyone knew exactly what this Act was doing. There's just practical proof in the record that nothing was concealed. I would also ask your honors to consider the case law in Tipton, which I mentioned earlier, as particularly relevant to this case because it also addresses an act that contained multiple sections, served multiple purposes, and the court concluded those purposes were relevant to the overarching caption, which was relative to growth. I'm going to now try and briefly address the repeal argument before turning to the contracts clause claims. There are 2 arguments that we have in response to plaintiff's repeal claim. We will stand by both, but for the sake of time, I will focus on the doctrine of permissive implied repeal. There's a portion of the caption clause in the Tennessee Constitution that prevents states from altering statutes not mentioned in their caption or in the body of the, not mentioned in their caption or properly signaled in the body of the act. But that portion of the caption clause only applies to a new law that explicitly changes the text of an old law. That has been the doctrine and the interpretation of the caption clause in place in this state for many, many years. And I would refer your honors to Chattanooga, Hamilton County, the Tennessee Supreme Court case from 1979 for more law on that point. Section 2 of the Act does not directly amend or repeal any part of PECA. It doesn't change one word of PECA, so it's constitutional. Now, plaintiffs argue it's unconstitutional because it implicitly alters PECA. And that is true. We agree that Section 2 implicitly alters an aspect of PECA in that while parties in collaborative conferencing can still discuss payroll deductions, they cannot discuss payroll deductions relative to membership dues. This implicit amendment does not implicate the contracts clause, and the Supreme Court has explained why. If one were to interpret the contracts clause as applying to laws that have been implicitly affected or amended by a new law, then the legislature could not do its job. The legislature would have to comb through page after page of Tennessee code and try and anticipate how a creative future litigator might claim that some narrow, obscure portion of the Tennessee code was implicated by or affected by a new law that's been passed. Now, plaintiffs...
Ms. Jones.
Yes, Your Honor.
I understand your argument, but the amendments, or I'm sorry, the statute specifically says notwithstanding and refers to PECA. So this is not some sort of wild search for something. I mean, it's referenced in there. It says notwithstanding that part, an LEA shall not deduct dues and wages. So how do you respond to that PECA is in fact mentioned in there as being altered or amended by this act?
Two ways, Your Honor. First, that was a courtesy of the General Assembly, not an obligation on their parts to identify PECA. It was a courtesy to the state as a whole, so they could recognize, oh, here's one area where we already do know something's been affected by this law. And second, the doctrine of implied amendment still applies here because not a single word of PECA has been changed. It has only been signaled that PECA is affected by another law, which corresponds with the intent of the doctrine of permissive amendment or implied amendment, which is that the General Assembly has no duty to find a statute, but certainly the General Assembly should not be punished for identifying other laws that could be affected by a law that they're passing. So
is that the nuance? It's affected, but it's not altered. I'm sorry, it's not repealed, revived, or amended?
Correct, Your Honor. There's not a single word of PECA has been rewritten or changed. There is certainly, and we agree, PECA has been affected by this new law, but it has not rewritten a single word of PECA. And because of that, the doctrine of explicit amendment or applied amendment comes into play.
Thank you.
Now, plaintiffs acknowledge this doctrine of implicit amendment and claim that it's allowed where the legislature enacts complex legislation on a single subject which affects a multitude of existing statutory provisions. But, Your Honors, the complexity of the new law is not a limitation that courts have recognized in the doctrine of permissive implied repeal. Just because a new law doesn't have to affect a multitude of parts or clearly affect multitudes of statutes to be protected by this doctrine. And finally, Your Honor, plaintiffs encourage the court to disregard the doctrine of implied amendment and to disregard a clear line of cases over 100 years old because those cases predate Chastain, which is an outlier case. They claim that because those cases came before Chastain by more than half a century, they should be ignored. But the age of precedent is not a reason to discard it, particularly when it's clear precedent spanning over 100 years. And plaintiffs have not explained how this court could disregard the very clear, very recent ruling of the Tennessee Supreme Court in State v. Enix that says outlier cases like Chastain.
Excuse me, Ms. Jones. This is the court reporter. I'm having trouble hearing you. Judge Martin, could you maybe mute yourself? I think that would help.
I think I failed to mute myself after I asked my last question, so I was shuffling. I will mute now.
Thank you so much. I'm sorry for the interruption.
Not a problem, and thanks for the heads up. So to return to my point, the age of precedent is not a reason to disregard it. And plaintiffs have not explained how this court could ignore the clear ruling of the Tennessee Supreme Court in State v. Enix, which says an outlier case like Chastain shouldn't be viewed as overruling prior controlling case law. Because the doctrine of implied repeal has not been overruled, it applies here, and for all the reasons I have just stated, plaintiffs are unlikely to succeed on the merits of their caption clause claim. I will now turn to the contracts clause portion of the argument. The test for the contracts clause is two-part. We agree with plaintiffs that the federal test should be applied here, given the similarity between the state and federal constitution. The threshold question under that test is whether a state law has operated as a substantial impairment to a contractual relationship. And this first part is dispositive, Your Honors. If the court finds either no impairment or that the impairment is not substantial, that ends the analysis. There is no contracts clause violation. However, even if the court finds a substantial impairment, that does not mean that plaintiffs win. Then we turn to step 2 of the test, which is whether a law is drawn in an appropriate, reasonable way to advance a significant and legitimate public purpose. So taking the first part of that test, and here we come into the subparts portion of the analysis, that step 1 has 3 subparts, which I will apply to the 2 types of contracts that plaintiffs have identified. The first subpart calls for states or courts to examine whether or not a law undermines a contractual bargain, whether or not the law interferes with the party's reasonable expectations, and whether the law prevents the party from safeguarding or reinstating the party's rights. That's in the United States Supreme Court's case of Savine from 2018 is where we're pulling those parts. Now, starting with the first category of contracts plaintiffs have presented to the court, that category is the memorandums of understanding between the schools and the unions. These are agreements that the parties reached as a result of collaborative conferencing under PECA. Here, Your Honors, in the 2 copies of the 2 memorandums of understanding that have been identified, there has not been a contractual bargain that has been undermined because both contracts contain reservation of rights clauses. Now, this analysis requires a level of close textual examination of the contracts. So if Your Honors don't mind, I'd like to share my screen. So
Go ahead.
Thank you. So we can dive into the exact text of these 2 MOUs. And I will start with the Memorandum of Understanding for Nashville Metro. Here, Your Honors, see the text at issue, which we assert is a reservation of rights clause. In the category beneath membership dues for professional employee organization, it says, whenever duly authorized by any professional employee on the form or forms designated for such purposes, and consistent with practices and policies of the district's payroll department, payroll deductions for membership dues for professional employee organizations will be honored. That language allows Metro Nashville to refuse to honor deductions if it is inconsistent with its policies. Now, plaintiffs argue that this is not a reservation of rights clause. Plaintiffs say that language, consistent with policies and practices, applies to the way employees authorize their deductions. So they must authorize their deductions in a way that's consistent with the policies and practices of payroll. That argument is incorrect for 2 reasons. First, it's grammatically incorrect, and I will try to not overstep in my love of English grammar when I break down the grammar of this, but the term whenever is an introductory clause that introduces an adverb clause that modifies the part coming after it. So I'll give a simple example. Whenever I run, I sweat. That first part, whenever I run, modifies the part coming after it. I sweat. In this case, we have what is basically a compound adverb clause, which means there are 2 adverbs that modify the part coming after it. Again, a simple example of that is whenever I run and drink water, I choke. Running isn't enough to make me choke, and drinking water isn't enough to make me choke, but whenever I do those 2 things together, I choke. Here, this clause says whenever duly authorized by an employee and whenever consistent with the policies and practices of payroll, automatic deductions will be honored. That's the natural, grammatically correct way to read this sentence. Plaintiff's interpretation fails for an additional reason, which is that it renders the words duly authorized meaningless. The clause says whenever duly authorized. Duly means in accordance with what is required and appropriate. So that first part says whenever authorized in a manner that is appropriate, an employee payroll deduction will be honored. And plaintiffs would have it read whenever authorized in a manner that's appropriate and whenever whenever consistent with practices and policies that are also appropriate for authorization, payroll deductions will be honored. It creates a very chaotic and somewhat confusing set of terms there because duly is rendered meaningless and it's unclear the purpose that it serves. So because there's no vested right in this statute and the school can change its policies in order to not deduct payrolls, not engage in automatic payroll deduction, there is no contract impairment that has occurred here. And I will turn to the Lawrence County MOU next, if you'll give me 1 second just to drink some water. So the Lawrence County payroll or reservation of rights clause that we've identified comes beneath the statutory savings clause. And I will share my screen one more time just so we can all look at this together. Under this statutory savings clause, there is a paragraph that contains the statutory savings clause. And then below it, there's a statement that the director of schools and the Board of Education shall retain the right to make necessary changes in local Board of Education policy and regulations in order to operate a sound school system. This language shows that the Board of Education could alter its policy in a way that impacts the memorandum of understanding if necessary to operate a sound school system. And that would change the automatic payroll deductions. Now, plaintiffs argue this is not a reservation of rights clause, but instead is a continuation of the statutory savings paragraph above it, and that it clarifies the memorandum of understanding, and I'm quoting from their reply brief here, cannot be read as the sole governing document of the district. That argument fails for 3 reasons. First, as I mentioned, the statutory savings clause is in the preceding paragraph. Second, this provision contains the words retain the right. And third, it is unreasonable to think that either the school or the union or anyone reading this contract would think that this memorandum of understanding between a school and a union is the only governing document in the school district. It's simple common sense that a single memorandum of understanding between a union and a Board of Education would not control all matters related to governing a school district. That interpretation is consistent with the pre-existing statutory protections in PECA, which say that PECA does not modify or repeal the rights and responsibilities of boards of education. That's in TCA 49.5.604. So the more reasonable reading of this language is that schools retain the right to enact policy that is needed to operate a sound school system, even though that policy might impact the terms contained in the document, being the memorandum of understanding. Because neither of the memorandums of understanding identified by plaintiffs contain clearly vested and enforceable contractual rights with respect to automatic payroll deductions, Section 2 of the Act does not undermine a secured contractual bargain. And just to put us in context, that applies to Part 1 of Step 1 of the Contracts Clause. So I promise you I'm going to try and speed you right along, but I found that language to be so crucial that I wanted us to be able to walk through it together. The second part of the 3 parts of analysis for Step 1 of the Contracts Clause is reasonable expectations. Here, I will focus on 3 reasons why the plaintiffs did not have a reasonable expectation under their memorandums of understanding that payroll deductions would continue to occur. First, their expectations were limited by the reservation of rights clause language that I just discussed. This is similar to the Energy Reserves case from the US Supreme Court in 1983, where there were contracts between national gas suppliers and public utilities that provided the terms were subject to change if there were changes in current and future state law. And the court found that that caveat in the contract showed that they had an expectation of future interference in the contract. Second, there was no reasonable expectation here because the unions have no expectation of guaranteed continued automatic deductions because their employees could change to other forms of payment at any time. In fact, plaintiff harped on this at length at the start of his argument that this automatic deduction is something that's voluntarily agreed to by the employees, and they could change it whenever they wanted to. So the unions could not have expected that the memorandums of understanding would always result in every employee having their union dues automatically deducted. Third, the subject of automatic wage deductions is a regulated area in Tennessee, which would have alerted both the schools and the unions to the possibility of future changes in that regulation. And this is important because in pizza, one of the cases that plaintiffs emphasize, it says the following: prior regulation to a field mitigates the substantiality of an impairment if it opens a contracting party's eyes to the prospect of changes in the existing regulations that may affect the negotiated terms. Here, there was prior and current regulation in PECA in two different statutes. First, PECA states in 49.5.609A1 that no MOU can violate state law. This suggests that state law is an area of regulation and that regulation is subject to change. But second, and far more specifically to this case, the exact issue of automatic deductions from wages was already regulated in Tennessee. Tennessee said you cannot have collaborative conferencing on automatic deduction of wages, on automatic deduction for political activities. This automatic deductions from the wage for political activities is a regulation that predated these contracts. It was part of the original PECA enactment. And it certainly put the parties on notice that the specific area of wage deduction could be subject to future regulation. For those reasons, the memorandums of understanding are not substantially impaired. I will now briefly address the membership agreements, which is a separate category of contracts. These are agreements between the union and the individual educators or the local employees. Here, there was no contractual bargain that was undermined because the schools who deduct the wages were not a party to these contracts. This was an agreement between the individual employees and the unions that, where available, the individual employees would pay their wages through automatic deductions. But those automatic deductions were not guaranteed because the schools could not be bound by these contracts. Now, plaintiffs argue they reasonably expected the schools to abide by the membership agreements, but as I just mentioned, the schools were not a party, and courts have repeatedly recognized that third parties are not bound by contracts. And the second is that membership forms themselves acknowledge that deductions might not be available. On the membership form, you will see in the Vaden Declaration, for example, the Vaden membership form, a little asterisk next to the word automatic deduction that says where available. So there was no contractual bargain undermined. Next, there was no reasonable expectation of ongoing payroll deductions because these were not binding forms of payment. Once an employee agreed to automatic payroll deduction in the membership agreement, that didn't mean the employee was forever required to use automatic payroll deductions. The employee could say, no, I want wage deductions to change. I want to start using my paycheck. I want to pay you in cash. So there was no reasonable expectation that an employee would continue to use automatic wage deductions. And finally, the reinstatement of rights factor. This is particularly important in Sveen. The Supreme Court said, where an individual party can easily reinstate their rights to cure whatever injury is alleged, then you don't have a substantial impairment of a contract. And here, the ultimate goal of this, the ultimate cure to the alleged harm is for the unions to continue to receive their union dues. That is easily remedied in this case. By plaintiff's own admission, thousands of teachers have already switched from automatic wage deductions to some other form of payment. For these reasons, Your Honor, under step 1 of the contracts clause, plaintiffs are unlikely to succeed on the merits, and that is dispositive. We could stop here and plaintiffs would not be entitled to interlocutory relief. But I will also turn to step 2 and address whether or not the state reasonably and appropriately advanced a legitimate public purpose. Now, there's been a little confusion in this case about aspects of scrutiny and deference appropriate on the second step. So I'll try and pin that down if I may. With respect to scrutiny, we agree that the contracts clause test requires something more than rational basis. That is clear in the case precedent. But that is not a burden of proof. That is a level of scrutiny. Courts have not required exacting amounts of proof to be given and evidence to support plaintiff's claim. Rather, courts require identification of a legitimate public purpose and that the act reasonably and appropriately advanced that purpose. Second, there's been some use, plaintiffs have argued that the second step test is whether or not the public purpose is reasonable and necessary. And that is a little bit of a conflation of several parts of the test, Your Honor. The correct test is reasonably and appropriately advances a legitimate public purpose. That necessary language comes from the deference given to the legislature. If the state is not a party to a contract, courts completely defer to legislative judgment as to the necessity and reasonableness of a particular measure. That's in the Supreme Court opinion Energy Reserves from 1983. So necessity comes into play in that courts defer to the legislature about the necessity of a particular measure if the state's not a party to a contract, which is a level of deference that applies to the membership agreements here because the state was not a party to those. Now, if the state is a party, then complete deference is not appropriate, but that doesn't mean there's a total absence of deference. The law just says complete deference is not required if the state is a party to a contract. Here, if the court were to adopt the Sixth Circuit's position, then the school being a party to the contract could be viewed as equivalent to the state being a party to the contract, which would result in reduced deference for the memorandums of understanding, but not, as the court has clarified, not an absence of deference. This second step, there's also one other factor that I'd ask the court to keep in mind that the Supreme Court has found significant, and that is when a regulatory measure applies regardless of contract. So here, the prohibition against deduction of wages or deduction of union dues from wages applies regardless of whether contract exists, regardless of whether there's a memorandum of understanding or school policy. It applies across the board. And the court in Exxon versus Egerton in 1983 viewed that general type of regulation as indicating an appropriate use of state power. In our briefing, Your Honors, we identified 3 legitimate purposes. I've taken up a lot of your time, so I will just stick with the primary one, which is public fisc. There's been a fair amount of discussion in the briefing and today about the legislative history that demonstrates that the cost to the state and the taxpayer was one of the primary reasons for Section 2 of the Act. Now, protecting public treasury is a legitimate aim of government. We have a Sixth Circuit case that cites that. And in Janus, the US Supreme Court said state spending on employee benefits is a matter of great public concern. It's true. We do not have a dollar amount that quantifies how much these automatic deductions have cost the state. But it cannot be disputed that this cost...
Ms. Jones, do we have proof that there's any cost to the state? I mean, what is the record on that? I know what the legislative history says because it's set out a lot in the complaint, but I'm trying to figure out what the basis for this is from the state's perspective in terms of it being some sort of legitimate public purpose. Is it just that people said that? Do we have anything to back that up?
Your Honor, we would state that dues don't spontaneously deduct themselves. Someone has to be responsible for processing these fees. And I would refer, Your Honors, to the Chouette case, in which the cost of processing automatic deductions was a primary and key issue. So the Chouette case is one that plaintiffs have cited. And in that case, it stated that for years, unions would reimburse the cost that schools bore in administering automatic deductions for their union members. So the Chouette case demonstrates that there were certainly costs because schools were automatically deducting from the wages money that they then sent to the unions. And the unions in Chouette, I believe this may have been I can't remember the state it was in, but it was not Tennessee. The unions in Chouette would then reimburse the schools for the costs of those automatic deductions. They did that for years. And it was these reimbursements that allowed the Sixth Circuit to conclude the state wasn't suffering a fiscal prejudice. But that's not the case here. Unlike in Chouette, where for years, schools were getting reimbursed for automatic deductions or wage deductions. Excuse me, I've said the word deduction so many times, it's starting to sound like a foreign concept. Here we have schools who are footing the bills for unions for over a decade.
But there's nothing in the record that supports that, right? You just want us to take judicial notice of that we assume there has to be some sort of cost. I mean, Mr. Colbert, on the other hand, says they just have to push a button and they're pushing other buttons for other deductions. I don't really know that that's in the record either, or how that all comes into play. But are you just asking us to assume that there's a cost?
Your Honor, we would argue it's not so much an assumption as it is a natural inference from the evidence that is in the record, both from Chouette and from plaintiffs' own contentions regarding the costs of these deductions that they have to handle. Banks normally impose these costs on the person seeking the deductions, so it's reasonable to assume that.
Come on, the state has a huge payroll and has a huge complex payroll system and human resources system. Are we to assume that the cost of the state would be comparable to a membership organization? I mean, I'm just not sure that's apples to apples.
But, Your Honor, I'm not sure. Excuse me. I'm not sure that the costs would be the same, but it does demonstrate that there are costs associated with doing this. Because the state has advanced a fiscal interest in a reasonable way, and it's not seeking reimbursements for these payments, by the way, it's trying to simply require individual employees and unions to take responsibility for their own union dues. That brings me to the conclusion of my contracts clause analysis, but if I may, I'd like to briefly distinguish this case from Pizza and Chouette because those cases were relied on so thoroughly by plaintiffs. This case on step 1 is distinguishable from Pizza because in Pizza, there were no reservation of rights clauses. In fact, the state conceded that the challenged measure impaired a right without even delving into the analysis of step 1 with respect to impairment of right. Second, in Pizza, there was no history of regulation. There was no restriction on conferencing for payroll deductions, whereas here we have identified multiple regulations, one that specifically put the parties on notice that automatic deductions were regulated with respect to political activities. And third, on step 1 of the contracts clause analysis, ease of reinstating rights. We've talked about easy pay. We've talked about the internet. Banks certainly have complex online processes that facilitate these forms of automatic payment. Internet easy pay was likely not available in 1998, and it certainly wasn't a factor that the court considered. Now, on step 2, with respect to this case in Pizza, in comparison, step 2 being the legitimate purpose of the state, there was no legislative history at all presented to the court. Here, we have presented extensive legislative history. The court can review it for yourselves to hear how accurate that recitation of legislative history is. And the concerns that plaintiff emphasized about muting unions to avoid remuneration is also not exactly applicable here, where the state has increased the minimum salary for teachers and has only expressed concern about the public footing the bill to assist unions. On Chouette, on step 1, again, there was no reservation of rights clause at issue in Chouette. There was no history of regulation. On step 2, the legitimacy of the public purpose, there was no discussion of legislative history in the case. And as I just referenced, quite significantly, there was no fiscal prejudice to the state in Chouette on step 2 because the unions were compensating the schools for the wage deductions. For all of those reasons, Your Honors, there is no likelihood of success on the merits of any of plaintiffs' claims, nor have plaintiffs shown irreparable injury. The complaint shows that the primary alleged harm here is easily remedied. Educators can check a different box on their membership agreements, and their dues will be paid to the unions. Maybe take a couple minutes to set up easy pay, maybe mail a check. That is not a challenging way to remedy a harm. Plaintiffs argue that once the transition has occurred, there's a possibility of harm since some employees might have overdrafts on credit cards and there are other possible issues related to employees paying things on time. But Your Honors, plaintiffs already faced that risk of harm from employees who opted out of wage deductions long before this law was passed. And this is a speculative expense. There's no clear proof that that harm will occur, and irreparable harms must be more than a speculative possibility. As for the maintenance costs, that leads directly to the balance of harm argument. Someone has to bear a cost here. Plaintiffs argue it should be the state. The state has passed a law. And on the balance of harm, the schools should not have to continue bearing these costs. In addition, on the balance of harm point, enjoining enforcement of a statute that automatically subverts the democratic process. Now, plaintiffs argue that where constitutional limitations are at issue, then it always supports public interest to enjoin the statute. But there's a nuance to that. There has to be a likelihood of success on the merits of the constitutional issues, and here we have demonstrated there isn't. So the simple fact that a constitutional challenge has been raised isn't enough to show irreparable injury. And finally, these statutes or these memorandums of law, they've only identified 2 that they've provided to the court. So a general injunction applying broadly would simply be inappropriate because there's not clear evidence showing that any of the other memorandums of understanding have actually been impaired because we don't know what they contain. For these reasons, Your Honor, plaintiffs have not met any of the factors to show they're entitled to temporary injunctive relief, and defendants respectfully ask that the court deny their motion.
Thank you so much, Ms. Jones. Mr. Colbert, if you would like to reply on behalf of the plaintiffs.
Yes, Your Honor, I will be brief. I know we've been going at it for quite a while. I just want to highlight a few points that Ms. Jones made and direct the court's attention in a slightly different direction. Speaking first to the Article 2, Section 17 challenge, the question before the court under Article 2, Section 17 is not whether something was concealed or was done secretively. It is a question of whether the plain, these are the Tennessee Supreme Court's words, the plain, absolute, unconditional, mandatory limitations on legislative authority in Article 2, Section 17 were observed by the legislature. This law is a new law that very clearly amends PECA. The state has effectively admitted that it amends PECA. It doesn't require combing through anything to find that this legislation amends PECA. As the court noted, PECA is referenced in the body of the act of Section 2, and it has been changed because this act limits the scope of collaborative conferencing on payroll deductions under PECA. This is exactly what happened in the Chastain case, where it's actually, this is a more obvious violation of Article 2, Section 17 than what we had in the Chastain case, because in Chastain, you did have to look to find out where the other laws were effectively amended by the new act in Chastain. In this one, you don't have to look because PECA is referenced in the body of Section 2. But this court is not free to ignore Tennessee Supreme Court authority that's on point in Chastain simply because the state wants to regard Chastain as an outlier. This court is bound by Tennessee Supreme Court authority. As to the contracts clause, the whole reservation of rights discussion is a bit of an exercise in grammatic gymnastics. The MNEA's MOU language that says consistent with practices and policies of the district's payroll department. This is at page 52 of the MOU, which is attached to the Pendergrass Declaration. That's not an authorization for unilateral elimination of dues deduction. It's just a requirement that the process of deducting and remitting dues has to conform to payroll department practices. The Lawrence County MOU language that mentions that the board retains the right to make necessary changes, make changes necessary in local board policy and regulations doesn't refer to the MOU at all. It refers to board policy and regulations. I agree with Ms. Jones. There's no reason to believe that every aspect of employment is going to be covered in an MOU. There are going to be board policies and regulations that cover matters that are not covered in the MOU. But that doesn't mean that the board is free in board policy to change an MOU willy-nilly, however it may see fit. And just to sort of put a bow on this question of whether these MOUs are binding agreements or not, the court need only look to PECA itself. In 495609 subpart C, the legislature has said that a memorandum of understanding shall be binding on the parties from the date of its approval by the Board of Education as an item on the agenda of a regular special call board meeting. So PECA itself declares that the MOUs are binding. I would like to point out that I think the state overstates the notion that payroll deductions are something of association dues are something that's highly regulated. And I know they said that in their response to our application for an injunction, and Ms. Jones suggested that today. In 1978, the legislature passed the EPNA, which was the predecessor law to PECA. And the EPNA was sort of modeled after the National Labor Relations Act, and it set out 8 mandatory subjects of negotiation. Payroll deduction was one of that subject, but the state doesn't play a role in those negotiations. It's not a party to the collective bargaining, wasn't a party to the collective bargaining agreements. Those negotiations occurred between local boards of education and teachers associations. PECA did not prohibit payroll deduction for political activities. You know, and all, I mean, PECA simply prohibits collaborative conferencing about payroll deduction for political activities. If that standard applied, even where only a small portion of a payment goes to political activities, as it does here, then teachers would not be able to negotiate to have their health insurance paid through payroll deduction, because absolutely every health insurance company out there spends an enormous amount of money, an amount that dwarfs whatever TEA spends on political activities. And finally, as to the fiscal interest of the state under the contracts, for purposes of the contracts clause, there's nothing in this record to demonstrate that there is a cost. The only evidence that's in the record, which is in the declarations that we filed in support of our application for an injunction, is that this is a simple keystroke by somebody in the payroll department to add a payroll deduction for association dues. So we respectfully submit that we have satisfied our burden, and we ask this court to grant the temporary injunction prayed for.
Thank you so much, both to you, Mr. Colbert, and Ms. Jones. On behalf of your clients, we will take this under advisement and issue a decision as quickly as possible. There being no further business, we will adjourn court.
Your Honor, may I ask a question?
Yes, of course.
Will the court's restraining order remain in effect until we get a ruling on this application?
I anticipate that it will. It has been, when we set this, I think it has been 15 days since it was entered. Under Rule 65, of course, we'd have to find a basis to continue it. I want to confer with the other judges before I answer too substantively, but we did set this with in mind the time period set out in Rule 65. Thank you all so much. Anything, Chancellor Fleenor, Judge Neill? All right, we will adjourn today. Thank you so much.
You are now done streaming.